Healthcare is too expensive. Employers are offsetting costs onto their employees. Who will make health benefits affordable for hardworking Americans and their families? You will. This is the Empowering Plans Podcast, a show dedicated to helping you once again emphasize the benefit in benefit plan. Now prepare to learn, plan, save, and protect with the FIA Group.
Well, hello there. It's time once again for a FIA Group Empowering Plans podcast. I feel bad, Pat, over there, our podcast producer. I feel bad using so many P's because I'm spitting on the microphone. And as I look at it, it's very clean. So I'm assuming somebody washes it off after every recording. I hope that's not you, Pat. This is Ron Peck, Chief Legal Officer of the FIA Group with you. Hi, everybody. And with me once again for this incredible episode of Empowering Plans with the FIA Group is the one and only Jennifer McCormick, our Senior Vice President of Consulting, FIA Group Consulting. Jen, how are you doing today?
Thank you for the emphasis on senior. Nothing makes you feel young like emphasizing that.
Listen, it has less to do with experience and more to do with quality and capability. And Jen, I can't think of anyone more capable of speaking about today's topic. That is specifically having to do with fiduciary duties, fiduciary status, a lot of the lawsuits that we're seeing popping up these days regarding that, and as it relates specifically to third-party administrators and their status or lack of status as a fiduciary, and sort of the expectations that we're starting to see as it relates to them and the good services they provide for self-funded benefit plans and plan participants. And, today's topic kind of came to front of mind for you and me, Jen, because of this Kraft Heinz lawsuit against Aetna relating to fiduciary duties. And I know you're going to talk a little bit about some of the specifics of that case for those who are listening and have no idea what we're talking about. But, it's interesting because this is a hot topic right now, fiduciary duties on behalf of TPAs and the services they provide. But it's funny because it comes and it goes, And this is not a new topic, right? The videos on YouTube and the blog posts online, they're getting lots of hits and people are saying, this is a new issue. If you're a TPA, take note. But it's really not. Every other year or so, we see a lawsuit or two about this topic. People talk about it and then they forget. And then a couple of years later, it comes up again. And, more locally, so a lot of people talking about this Kraft v. Aetna because they're two behemoths going at it, right? Aetna is a large player, but so are Kraft, right? Kraft Heinz, big company. Another big company, but more local, the Mass Laborers Health and Welfare Fund actually filed a lawsuit in the First Circuit against Blue Cross Blue Shield of Massachusetts. So that's in our backyard, more or less over the same issues. And we'll talk about that one as well. And that's a recent 2023 case. But, these issues, they go back pretty much since the founding of ERISA and self-funding and health benefit plans, but also pension plans and retirement plans and 401k management as well. The question of, is an administrator of an ERISA plan a fiduciary, when and when not? And, it's interesting because back in, I believe it was in 2022, so only a year ago, there was a case, a lesser-known plaintiff, Rebecca Smith, not quite Kraft or Heinz. Rebecca, I still appreciate you, filed a lawsuit against United Health. And this was in the United States District Court for the District of Minnesota. So not quite our backyard. Same exact issue. So let's go ahead and jump in and find out what that issue is. In that lawsuit, Smith v. United Health, Ms. Smith and other similarly situated plaintiffs were basically accusing United of breaching their fiduciary duty that was owed to Ms. Smith and other participants of self-funded benefit plans. They were arguing that United violated its fiduciary duty when it committed what's called cross-plan offsetting. And Jen, you're going to talk about that in a second because it popped up again in this Kraft v. Aetna lawsuit. But in a nutshell, basically what we're having happen in general, and I should explain what the cross-plan offsetting is as it's defined. Basically what happens is you have a large carrier, Blue, United, Cigna, Aetna, the larger players in the insurance market. And what they're doing is they're providing what we call administrative services only, or ASO services, which are basically third-party administrator or TPA services that they're providing to a self-funded plan. And the only difference between self-funding and traditional insurance, for those who don't know, insurance, the carrier pays medical bills with their own money. When they're performing ASO services, they pay medical bills with the client's money, the plan's money. So it really just kind of comes down to where's the money coming from. And what's happening is the large carrier apparently either overpaid a provider. So a medical bill came in for one amount, maybe they applied some sort of a discount, somebody made a mistake with the math, something you and I, Jen, would never do, right? And they overpaid. And so when another bill comes in for the same provider, they say, hey, I paid you too much last time, so I'm going to offset the overpayment by underpaying you this time. And so it all comes out in the wash. And in the end, you got the right amount of payment in total between these two claims. I paid the right amount in total between these two claims. And it's all copacetic at the end of the day. Overpaid on one, underpaid on the other. Boom, boom, comes out in the wash. And I think that's the way math works. The problem is when the carrier is paying with its own money, it's okay to overpay on one claim, underpay on the other, and it equalizes out. The problem is when they overpay with one plan's money and underpay with another plan's money, because unlike an insurance scenario with self-funding, overpaying with one plan's money, that plan has still overpaid. And even though you underpay with another plan's money, that doesn't benefit the original plan. In other scenarios, they overpaid or underpaid with their own money, the carrier that is, and then they make good by offsetting with a self-funded plan. And so the issue is here you've got them sort of commingling plan assets, overpaying with one, underpaying with another, overpaying with their own money, underpaying with another, underpaying, right? Maybe keeping the money for themselves and pulling it from a self-funded plan. And the problem is every single plan is supposed to be administered or managed on an island in a vacuum. Just because you overpaid with plan A's money doesn't mean you then underpay with plan B's money. That doesn't benefit plan A, right? And even if they take the money from plan B and move it to plan A to resolve the overpayment, it still is a violation of ERISA because that's a misuse of plan assets. That's not something that the plan envisions as an allowable use of their plan assets. So, this application of sort of traditional insurance practices, this offsetting to a self-funded model, it just doesn't work. And that's just one of many accusations we're seeing here. So, Jen, I don't know if you want to talk a little bit about the cases that we're seeing more recently, that being the Kraft case and then the mass laborers case, and what it tells us about whether TPAs are fiduciaries.
Yeah, and I certainly think it's important for us to go over these cases to get an understanding of what's happening. But I also think that it's important to at least speculate about why this is happening, because what you have said, this is not something that's a new issue. This has been happening for many years, for decades, and only now it seems like it's becoming the topic of so much litigation. But why? And maybe it's because the cost of healthcare is going up. Maybe because healthcare has been such a hot topic generally in this country or in the world. Maybe because there's a change at leadership at the particular company. And one of the things that this change in leadership is trying to do is to come in and review benefits and identify where there could be financial savings or financial opportunities. But it also could be because the laws are changing and evolving. And as we're starting to ensure compliance at a plan level or at a TPA level with the various laws, we're starting to investigate things for transparency purposes that maybe we haven't before. And we're starting to see this with the Consolidated Appropriations Act just a couple of years ago. Two of the things that came out of that in those regulations were the No Surprises Act. And under the No Surprises Act, there are a lot of requirements. We're working through them all now about what the goal of it is and who's responsible for doing what by when. And it's highlighting the pricing of claims and what the correct way to handle that would be and what amounts you should submit and how you're supposed to calculate that. So it's drawing attention to those situations. But the other thing that the CAA brought to us was the N2TL written documentation requirement. And that's a result of the mental health parity rules and ensuring that plans are documenting everything in writing to ensure that they're administering things in parity. And as part of that, one of the key issues that the agencies were looking for was to make sure that not only were things being done in parity as far as how benefits were being provided, but the agencies were very, very interested in how credentialing was being handled by the providers, how reimbursement rates were being set up and dictated within the plan terms. So maybe with all of these new regulations and the reasons why these have gone into place, it's uncovering things that maybe people didn't necessarily think of before. So in particular with this Kraft Heinz case, Ronnie talked about a lot of the underlying issues here. One of the major issues here is that these plans, these employers are starting to investigate situations where maybe the administrator in the case has data, has information about the plan's medical claims and how things are being processed and how they're being paid, and the opportunity because of their status or their role or their side to potentially engage in offsetting, and maybe that would not otherwise be something that they would realize but for the network relationship. So the offsetting here in the Kraft case was one of the major issues where the plan administrator is claiming that by engaging in this type of activity, it is a breach of their fiduciary duties, creating fiduciary duties on behalf of Aetna because they are commingling funds with other plans. And that is one of the rules under ERISA, that there is no permission to commingle funds from different plans in the same account. That also by having this in place, that by offsetting the Kraft claims against other plans who are maybe not on the Kraft plan or participants who are not on the Kraft plan, that it is creating fiduciary charges against Aetna for doing that. The other piece of the Kraft case that I think is pretty interesting here that they're claiming or that they're investigating is that by having these network relationships that the Kraft plan participants are able to access through Aetna, that they're being charged an insane amount of fees or excessive fees for how the repricing of their claims are being handled, and that there are these contracts that maybe they don't necessarily have access to or they're unable to review, that by having those in place, that potentially that there is the opportunity for Aetna maybe to not review claims or to question fees or to question the repricing amount to the same extent that they otherwise would because of these agreements that are in existence. And that is creating other fiduciary questions or concerns. So the overall question in this Kraft case is essentially, where's the line? What sort of activities would an administrator be allowed or be permitted to do and undertake as far as their obligations without crossing the line of being a fiduciary? So by having agreements in place, by doing these cross-plan offsetting activities, are those in fact fiduciary duties, or are those TPA or administrative type of duties? And I think it'll be really interesting for us to see and continue following this case to really figure out what exactly the courts will decide, because it's going to have a big impact on not only this particular plan, but setting a precedent for going forward for how plan design should be handled, how administrative agreements should be handled, how claims should be processed, and the actual obligations that a plan sponsor has as an employer and the responsibilities that an administrator should have. And where is the line? Where does it get blurry? Where does it get fuzzy? That is a question that's still outstanding. So there should be an extreme amount of caution right now for plans and looking at these different arrangements or agreements they have in place to really figure out where the safe spot is and who should be doing what. And this was a similar issue to the mass laborers case, Ron, that you also had brought up here too. And the claim in this particular case was that the functions that the Blue Cross Blue Shield of Massachusetts functions that they were actually providing on behalf of the fund in this case were not administrative duties, that they were fiduciary duties, and they were questioning the amount of control that they had over plan assets, over how the plan was managed, and the type of authority that they actually had to pay or to reprice or to engage in certain sort of recovery or settlement efforts on behalf of the fund. So in that particular case, it came out that the TPA was not acting as a fiduciary, and solely the functions that it was handling in that particular case were deemed to be administrative, that there are certain obligations that the administrator is required to do, that they should be doing when it comes to reprocessing claims, working through the general business functions, the general business decision making, using the plan terms, using that as a guide, following along with the duties administratively that they are obligated and required to provide under the terms of their agreement, and that by doing that, there's not the level of discretion that would otherwise consider that function to be considered an ERISA or fiduciary type of function. So this potentially is at odds with what the Aetna case is claiming here, the Kraft Heinz case is claiming. So we'll have to see here, one on one and the other potentially on the opposite end of the spectrum, where really is the line for what would be an administrative duty and what would be a fiduciary duty. And we don't know all the facts here too, but it's very interesting to see a lot of attention that is being drawn to these particular cases. So I know that I just said a lot, but using those two cases as a discussion point, what is it that you should do with your plan? What is it that you should do if you're an administrator, Brian?
So here's the thing, and I'm going to say something, and this may come off as controversial, Jen. When you say, what should you do? What should you do? Let's say hypothetically a third-party administrator, TPA, is listening to this podcast and they're saying, well, am I a fiduciary or am I not? And when you look at these two cases, right, the Aetna case, the lawsuit is literally, hey, you breached your fiduciary duty and thus you owe me damages. And sort of the baseline question before you get to did you breach your duties are, did you have a duty in the first place, right? And that's what you're saying, Jen. Are you a fiduciary or not? Because if you're not a fiduciary, then you can't breach fiduciary duties. And that's sort of how that mass laborers case shook out is, well, you didn't breach your fiduciary duty because you weren't a fiduciary in the first place.
Exactly.
But here's the controversial thing I'm going to say. I don't care. I don't care if you're a fiduciary or not. Hold the phone, right? Because here's the thing. People are asking, am I a fiduciary or not? But the next question is, did I do something improper or not? And if you're doing something that is improper, an abuse of the plan of its assets, and it's determined that you are not a fiduciary, and therefore that improper action is not a breach of your fiduciary duties because you didn't have a duty to breach in the first place, that doesn't mean you're off the hook. That just means that the parties, the aggrieved parties that you have harmed with your improper action, are going to have to come up with another way to sue you. It may be a breach of contract. It may be some sort of negligence claim. Maybe they have to go to state court instead of federal. One of the benefits of suing somebody for breach of fiduciary duty under ERISA, which is a federal law, is that you get to sue them in federal court. And you know what? That's preferable for some than suing somebody for breach of contract in state court. But just because I fail to prove you're a fiduciary and therefore I fail to sue you in federal court doesn't mean I'm going to say, oh, shucks, you got away with it and go home. All right, I'll go with the B team. I'll sue you in state court for breach of contract or any other number of things. So as a TPA or a plan administrator, yes, of course, ask, am I a fiduciary? Do I owe this higher standard of care? Being a fiduciary just means that you're supposed to put the entity on whose behalf you're a fiduciary, put their interests ahead of your own. Somebody can't point to it and say you did something that was detracted from them for your own benefit. That's a breach of your duty. Okay, but even if you're not a fiduciary, still, you should be looking at what you're doing and you should be determining, am I putting my client, the plan members in the best possible position? And if you're not, don't think you're off the hook just because you're not a fiduciary. There may still be negative repercussions for you. And we're talking about this offsetting as an example where you're literally one plan has overpaid, another plan gets a windfall by underpaying, and you're like, oh, hey, maybe I'll pull some money from the underpayer and give it to the overpayer and we're all settled. You can't play those games. They're going to come after you regardless of whether you're a fiduciary. But there are other issues. The bottom line is what we're talking about here is a conflict that we have talked about in webinars and other podcasts between ERISA and the plan document and the plan language and private contracts with the ASO, your administrative services agreement that you as a plan sponsor, if you're an employer, that you probably signed, you have no idea what you're signing, and you're basically giving them the keys to the castle, and you're saying, do whatever you want with my money. Even if that means that contract says, and by the way, the data is proprietary. Your pricing, proprietary. Even though it's my money, I have no right to the claims data, and I have no right to see what you're doing with my money. I have no right to audit. That's in the contract that they're signing. Even though ERISA and the plan document require me as the plan sponsor, as the plan administrator, to audit the claims, to monitor the data, to make sure the funds are being used properly. That's on the one hand. And then on the other hand, I'm signing a contract that says I'll never do any of those things. That's number one. Number two, those network contracts with providers basically says, I'm going to pay whatever you charge me minus a discount, 30 days, no questions asked, no audits allowed. Meanwhile, the plan document says, I'm going to make sure we're not paying too much. I'm going to make sure we're paying appropriate rates, reasonable rates, usual customary. Again, a conflict between a private contract, the network agreement, and the plan document and ERISA. And when you look at these lawsuits, you're seeing that conflict play out. Kraft is saying Aetna won't let us see the claims data. That's a violation of ERISA. Meanwhile, Aetna's saying, I bet, and I haven't seen it, but they could argue, listen, the only person who violated ERISA and violated their fiduciary duty is you, Kraft, when you signed a contract with us that said that this data is proprietary and that you'll never audit it. Why'd you sign a contract that under ERISA in your plan document, you weren't allowed to do? You weren't allowed to agree to those terms. In good faith, we trusted that you have the ability to give us that right, to protect that data, to treat it as proprietary. Therein lies the rub. Self-funded plan sponsors should not be signing contracts or allowing their agent to sign contracts on their behalf that signs away or gives away rights and duties and obligations that they have under ERISA. That includes getting your hands on your claims data, monitoring the claims, protecting the plan assets, and ensuring claims are being paid in accordance with the terms of the plan document. And any contract that says that you or someone else is going to do anything else but that is in conflict with ERISA, and it's going to result in these issues. And, it's strange I'm saying here, right? And I'm defending, for instance, an Aetna or a Blue Cross or United in these lawsuits. But at the end of the day, what are they doing? They're doing what the contract says they're going to do. And I think that in some way is kind of what the Blue Cross court was saying, is that Blue Cross was performing administrative ministerial tasks that they were required to perform in accordance with their contract. The contract basically says, hey, Blue Cross, violate ERISA and pay these claims without looking. Obey the network contracts above all else. Blue Cross says, okay, that's what the contract says. That's what we're going to do. Who's responsible for having signed a contract that potentially conflicts with ERISA and the fiduciary duties of the plan administrator? Is it the ASO? Is it the carrier? Or is it the plan sponsor that signed it in the first place? I don't know. But that's where that conflict, I think, is originating from. And I don't think that you're going to be able to continue to sign contracts that are contrary or conflict with ERISA and the plan document for much longer, or we're going to see a lot more lawsuits like this.
No, I think that you're absolutely right. Yeah, this is certainly the issue and a key issue for administrators to follow and keep an eye on as we see what unfolds and what the court decides in this case. But these are novel questions that have not been thoroughly litigated about the contractual rights to certain information versus the potential ERISA obligations and responsibilities that you have. Is this going to be a whole new opportunity to rewrite the rules for what you can and should be able to access, and the extent to which what functions administratively versus fiduciarily are going to be appropriate and relevant for who should be on what side? I think it'll be really interesting and something that we'll have to keep an eye on and have to have a part to it some point in the future.
Absolutely. Well, we're going to keep an eye on this. I am just fascinated to see, whether the courts are going to say that a contract which potentially conflicts with the fiduciary obligation of the plan administrator is still a valid contract. If I, as a plan administrator, am obligated to audit claims data and I go and I sign a contract that says the claims data is proprietary and I'm not allowed to look at it, is that contract enforceable? or is it void for illegality, or any other number of arguments? Was it valid in the first place? Did I have the right to agree to those terms when I had a pre-existing fiduciary obligation to do otherwise? I love these cases. It's so interesting because it's got a little bit of the legal flair. It's got a little bit of the business issues. There's all sorts of things involved. So it's some spicy stuff. We're going to keep our eyes on it. But in the meantime, my one word of advice to every third-party administrator out there is, if you handle the money, if you make any decisions, if you exercise any discretion, if you do anything other than have the plan sponsor literally tell you what to do with every single claim and appeal, if you're not doing that and you're exercising any discretion in your day-to-day administrative duties, assume you're a fiduciary. Maybe you're not, but work under the assumption that you are and keep the plan's best interests in mind, and you'll stay out of trouble regardless. That's my approach. So with that, Jen, any closing thoughts?
No, thank you, Ray. I think you hit it. Important issues to unpack here and keep an eye on.
All right, this is not the end, folks, but it is the end of the podcast. Thank you so much for joining us today for the FIA Group's Empowering Plans podcast. On behalf of myself, Ron Peck, Chief Legal Officer of the FIA Group, and Jennifer McCormick, our Senior Vice President of Consulting, as well as Pat, the man, Santos. Thank you, my friend. Be well, take care of yourself and your plans, and we'll talk to you soon.